Peter Zovak. I'm the Deputy Director of Housing for the Community Development and Housing Department. And on behalf of all the organizers of this event, I'd like to welcome you here. We understand that lately the housing crisis has impacted quite a few people, a lot here in Glendale, Southern California, all over the nation. And so we wanted to be able to provide you, the residents, as much information as possible as you go through this time. And so we hope that you find the information and use it to your advantage. I hope you find it helpful. If there's not some information, there's some information that's not covered in any of the topics today, feel free to come up to us at any of the tables, and we'll be able to talk to you one-on-one and be able to get some additional information to you later next week as well. We have a short period of time, so we have a short range of topics that will be going on today, and I'll be taking you through the various topics that we'll have, the sessions, and where those sessions will take place. For right now, though, we have a number of people that like to share a few words with you. The first one being our chair of the Glendale Housing Authority and Council Member Bob Yosefian.
Good afternoon, ladies and gentlemen. It gives me great pleasure to give you this opportunity to learn a little bit more about the Glendale Housing Authority and also take the opportunity to answer your questions and try to deal with some of the issues that you're facing day to day. As you know, as a member of the Housing Authority, all of my colleagues have worked very diligently to try to provide the housing needs of this community. Among us today is also one of my colleagues, a member of the Housing Authority, and also former mayor and the council member, Ara Najarian, who's standing all the way back there. There's Ara. Wave, Ara. And Madeline will come right up after I'm done speaking. But I would like to take this time to thank the Community Development Department staff for working very hard, especially with the Neighborhood Legal Service of Los Angeles putting this forum together. Let us not forget that our city attorney has been working very diligently with them, and as you know, attorneys charge a lot of money, but they have decided to come in here and answer a lot of your legal questions. So at this time, I would like to ask Madeline Blake, who is the head of the department, to come forward. I'm not going to speak too much because I want you to get as much information possible. But while Madeline is coming up, I just want to give you a couple of little anecdotal information. Since we have been around, which is in year 2000, from 1990 until year 2000, we have built over 487 units. These are real units. These are rooms that we actually built in this city, compared to the decade of the 70s, which there were only about 166 built. And even though it costs a lot of money, we have spent millions and millions of dollars trying to do that, something at the tune of $63 million to do this. Madeline?
I also would like to welcome all of you here today. I know a number of you are here for different reasons. Some of you are here because you rent and you want more information as a renter, and maybe you're interested in the smoking ordinance, maybe you're interested in renter rights, property rights, what's happening with code enforcement. Some of you may be here because you own a home or because you want to buy a home. And we're going to cover a lot of different topics here today, both for people who own property, people who rent, and people who own or want to own a home. I'm going to talk just a little bit for a minute about the issue of home ownership. I know I don't have to tell you that owning a home is getting more and more difficult every day for a number of reasons. Number one, the cost of housing is high. Number two, lending is getting very difficult. Banks, and I'm sure Bank of America is here, Wells Fargo is here, they will talk to you about what's required now to buy a home. But I know all of you, majority of you, I would assume, live in Glendale. People want to live in Glendale for a number of reasons. It's a beautiful community. It's a good location. It's safe. Our schools are good. And many of you have friends and family here, and you want to stay here, whether you rent or you own. But I don't know if you know, but only just about 39% of the housing here in Glendale is ownership housing. The rest is rental, and I'm thinking many of you do rent. The Housing Authority does have a first-time homebuyer program for those of you who may be interested in purchasing a home, and one of the workshops today will talk about that. Just to give you an idea about the cost of ownership housing here in Glendale, in August, a couple of months ago, the median home sales price in Glendale was still $600,000. And that was about a 6.5% drop from 2007. So what that says is it may get a little bit easier, but the cost of housing in Glendale still is pretty high. And to even purchase a home at that price, a family needs about $160,000. However, we are seeing more condominiums become available, and so more people are getting more interest in the purchasing condominiums through our first-time homebuyer program. So if you are interested in that, you may want to attend that particular workshop. Another issue for people who own their homes now is the issue of foreclosure, which we hear about. I mean, every time we turn on the television, we're hearing about the economic situation and the challenges with people keeping their homes as a result of very lenient criteria. For the last couple of years, people were able to purchase a home, but now with the market being what it is, it's difficult for a lot of people to keep these homes. From April through June, there were 100 home foreclosures in Glendale. This is 3 times the number that we had in the same period in 2007. We estimate that there are about 22 foreclosures a month. That's what we'll be seeing in 2008. 40% of the families in Glendale that get behind in their payments and receive a notice of default are losing their homes at this time, and that's much higher than in the past. People were able to figure out a way to keep their homes. However, there is a new housing bill that was passed. I think some of the vendors have some very good information about that, and as I say, there will be a particular workshop on the issue of foreclosure if that's something that is of interest to you. The other issue that we'll be talking about today in another workshop is for senior citizens who may have challenges or may want to cash in on the home that they have. People may have had a home for a long period of time, and even though the market has dropped, it still has a very good value compared to what people bought it for. And so we will have a session on reverse mortgages, and that's an issue whereby people who have had their homes for a long time, it's a way to kind of sell your home and work with a lending institution to get the money for your home. And the people who have lived in their homes for a very long time have a number of issues. One, they may want to sell and get the cash. But the other thing is sometimes maintaining it is a challenge. And the City of Glendale Housing Authority does have programs to help people make repairs on their homes, particularly for senior citizens. So as you can see, we have a number of workshops that will address a variety of issues relating to home ownership, whether you want to buy, whether you're having a challenge keeping your home, or whether you've had your home for a very long time and either want to look at cashing in on that or maintaining it. So again, I want to thank you all for coming, and at this time I'd like to introduce Neil Dudovitz, who is the Executive Director of Neighborhood Legal Services, who is a partner of ours in this workshop.
Thank you very much, Madeline, and good afternoon to all of you. Such a beautiful day out here today. It's sort of hard to be inside, but on the other hand, as Madeline noted, housing issues, your ability to stay in your home, purchase a home, or maintain your home are at a critical juncture here today, and I'm sure that's why you're all here. We're very happy to, pleased to be able to participate and help in this endeavor. You know, I think Councilmember Yosefian sort of, we met and he kind of whispered in my ear several months ago, so somewhere he had a crystal ball, that we really needed to sit down and try to help people in the community on housing issues, and that was before everything sort of crashed. So we were a little bit ahead of the curve, unfortunately, because these are very difficult issues. And I do want to acknowledge him and his role in this, and certainly the Community Development Department and Madeline and Peter, as well as the City Attorney's Office, who really has always worked cooperatively with Neighborhood Legal Services in these endeavors. We have a long history of working with the City of Glendale, and as many of you know, we have an office here in Glendale, which opened in 2005 in Adams Square. And we provide a wide variety of assistance to you. Housing is only one of them. We do issues around public benefits, consumer problems, immigration, employment, community development, assistance with family law matters. So we have a table just outside here on any problems. Feel free to stop by the table. Adams Square is also, by the way, the home of Glendale's newest branch library, which is located in our building, and we're very proud to have them as our neighbors and urge you to visit. We've worked with the City of Glendale on housing matters since 2002 in helping Glendale adopt a just cause eviction ordinance. Glendale happens to be one of only a dozen cities in the state of California that requires landlords to have a reason before asking a tenant to move. And we really have commend the city for taking the leadership role they have in trying to ensure that tenants' rights are protected. Today, as Madeline outlined to you, there are a whole lot of homeowner and landlord-tenant issues out there that many of you face. We know people are losing their homes because of bad loans. Some renters are being evicted because the home in which they're living has been foreclosed, and they end up getting evicted from that. And everybody, part of the American dream is we should all have an opportunity to purchase a home, and as Madeline again outlined, it's become harder and harder to do that. So we urge you to take advantage of all of the assistance that's available to you today. It's quite an array of agencies and lots of information. If you own a home and are having trouble with your mortgage, there are some new federal policies that may be able to help people renegotiate. I know it is very difficult to do that, but Pasadena Neighborhood Housing Services, I believe they're going to give a talk about 3 o'clock today, and if you're in that circumstance, I urge you to attend. And if you've had fraud that led to your mortgage problems, Neighborhood Legal Services also may be able to help you in that situation. So in that case, I would certainly invite you to stop by our table. And if you're renting and the owner of your home is in foreclosure, there may still be opportunities to you to protect your tenancy. And Stephanie Hafner, who's standing here in the back, who's our housing attorney at Neighborhood Legal Services, is going to talk with you about that issue also at 3 o'clock right here in this room. So again, I urge you to take advantage of everything that's available to you here today. And if you can't get your help today and you still have questions, you'll see there's plenty of flyers at our table there. We have an 800 phone number. Feel free to call us, and we'll do the best we can to provide you assistance anytime. Thank you.
Welcome, everyone. My name is Lucy Varpetian. I'm with the City Attorney's Office in the City of Glendale, and I'm here to talk with you about the Just Cause Eviction Ordinance in the City of Glendale. In 2002, the City of Glendale, in response to certain economic conditions, decided to adopt the Just Cause for Eviction Ordinance. And the goal was to preserve for the citizens in the City of Glendale safe, habitable, well-maintained, and stable housing environment without the fear of any reprisal on the part of the landlords. So the ordinance was adopted. It was drafted by our office. It was adopted in 2002. There were some changes that came about in 2003, and then some more changes that happened just recently in 2008. And we'll talk a little bit about that too. So when we look at the Just Cause Eviction Ordinance, the first thing we look to is what rental units are applicable to the ordinance. So for rental purposes, dwelling units available for rent in the City of Glendale are subject to this ordinance with the exception of certain conditions. So the first one would be units located on a parcel containing 2 or fewer dwelling units. So the ordinance applies only to units where there's more than 3. If it's if it's 2 or fewer, then this ordinance does not apply to that particular rental unit, even if it is a rental. The ordinance also does not apply to units owned by government or rent subsidized by government, meaning things like Section 8 or other ordinances or other housing that's owned by the government. So the ordinance does not apply to those. It also does not apply to units where there's intake or case management as part of the agreement. It does not apply to rooms in hotels or other types of extended care facilities. And it also does not apply to boarding houses rented for less than 60 days. So those are conditions, those types of units do not apply, this ordinance does not apply to those types of rental units. There's another exception that is in the ordinance, and that has to do with the 1-year lease exemption. And this part is pretty unique to the City of Glendale. Most cities that have a rent stabilization ordinance or a just cause eviction ordinance generally do not have this exemption in the ordinance. And what this says is that a dwelling unit is exempt from the just cause eviction ordinance if the landlord offers in good faith to the tenant or prospective tenant a written lease which has a minimum term of 1 year. So the landlord has to make this offer of a lease that's in writing with a minimum term of 1 year. And other conditions have to be met as well. The tenant or the prospective tenant accepts in writing the offer for the written lease. So there's an offer on the part of the landlord, and the tenant now has a choice. The tenant can choose to accept the lease, which then makes the unit exempt, or the tenant or the prospective tenant can reject the written lease for 1 year with a 1-year term, either in writing or by failing to sign the lease. So when that happens, even though there's no written agreement between them at that time, the unit is still exempt under the just cause eviction ordinance. Next. If the tenant rejects the lease, then the landlord and the tenant may enter into a written rental agreement for a shorter period of time that has substantially the same terms as to the written lease that was offered to the tenant initially. So they're not precluded, if the tenant rejects the lease, they're not precluded from moving forward and entering into an agreement for a shorter period of time. Sometimes the tenant does not wish to be locked in for 1 year. They could choose to enter into a 6-month lease. But at that point, the tenant needs to be aware that the ordinance, the just cause eviction ordinance, is no longer applicable. And again, the same rule applies for the existing tenants. Next slide. The term or of the written lease shall be substantially similar to the then existing rental terms that the landlord and tenant have. There's two other conditions that need to be met, that need to be addressed in the written lease and or in the subsequent lease that they adopt, or in the lease itself, and that is that this language needs to appear in the lease. And basically it says that this rental unit is exempt from Chapter 9.30 of the Glendale Municipal Code, just cause eviction, because the landlord's offer of a one-year lease, which has a term of 1 year. The next condition is that the rental rates must be set in the lease. So these are things that you, as a tenant, need to be looking out for to see if, in fact, the landlord has met the conditions of the law. And as a landlord, you need to make sure that you've included these provisions in the agreement. Next. Now, what happens if the landlord and the tenant have entered into this one-year lease that is exempt under the ordinance? If the landlord and the tenant wish to renew the exempt lease, then 90 days prior to the expiration of the lease, the landlord may offer another one-year lease. By doing so, that exempts the unit from the just cause eviction ordinance further. And again, that applies even if they agree to a shorter period of time. If there's no lease offered at the end of that one-year term, then the unit reverts back to being subject to the just cause eviction ordinance. If the landlord and the tenant do not wish to continue their relationship, then at the term of 90 days prior to the expiration of the lease, the landlord needs to provide the tenant of a notice of non-renewal. And at that point, no reason needs to be provided to the tenant for the termination. So what are the justifiable reasons for eviction in the city of Glendale? There are 12. And we'll go through them one at a time. The first is failure to pay rent. If there's no rent, if the tenant fails to pay rent, that is a justifiable reason, a just cause for eviction. The next reason would be the violation of a lawful obligation, be it in the lease or otherwise. Another reason, the third reason, is causing a nuisance or damage to the property. That's the third reason. Using or permitting the use of property for any illegal purpose. Again, these are reasons why the landlord would be permitted to evict a tenant in Glendale. Subtenant not approved by landlord, and an example of this is the landlord and the tenant enter into an agreement, and at some point the tenant moves out but brings in someone that the landlord has no idea who that is. And that would be another reason why the landlord would be able to evict a tenant. Refusing landlord reasonable access to the unit for lawful purposes. This comes in when the landlord needs to make repairs or show the unit, provides the tenant with the 24-hour or longer notice, and the tenant just refuses the landlord access. The landlord seeks to demolish the unit or to do major rehabilitation. The landlord, and then the next reason is the landlord seeks to occupy unit for himself or herself, family members, or a resident manager. The next reason is the landlord is removing the unit from the market permanently, so the unit's not going to be available for rent again. The next reason is the landlord needs to comply with the order to vacate, and that usually happens when the city comes through and provides a red tag and says it's no longer safe for someone to occupy the unit. That would be another reason why the landlord would be able to vacate. The next reason is the landlord needs to comply with the contractual agreement relating to qualification and tenancy, and that usually happens if there's an income component where you're in low-income housing, and as a condition of your tenancy, you need to maintain a certain income, and now you're earning more money, and therefore you're no longer eligible to continue to live there. And the last reason is violation of the smoking ordinance, and we'll talk a little bit more about that. There are 4 reasons in here that are in green and in italics. And there's a reason for that, and we're going to talk about those. Those have to do with the demolition of the unit. The landlord seeks to occupy the unit for himself, removing the unit from the market, or to comply with an order to vacate. And the reason that these are in green is that under those circumstances, the tenant would be entitled to relocation. So we're going to talk a little bit about relocation, but those are the reasons when relocation would come into play. So let's talk about relocation now. So if the eviction is based on major rehabilitation or demolition of the unit, the landlord seeks to move in for himself or herself, the family members, or a resident manager. The landlord seeks to remove the unit from the market altogether or needs to comply with some order. Then, under those circumstances, the tenant is entitled to a relocation fee. And let's talk about the amount of the relocation fee. It's 2 times the fair market rental value as established by HUD plus $1,000. So the way you factor that out, you look to see how many bedrooms are in your unit. If you're living in a 2-bedroom unit, then you look to see what HUD has established as the fair market rent for a 2-bedroom unit. You take that amount, you multiply it by 2, you add $1,000, and that's the amount that a tenant is entitled to for relocation. There's no relocation fee. Even under those conditions, there's no relocation fee if the tenant received notice of application to subdivide or convert to condos. So the landlord had notified the tenant prior to moving in that they had an application was submitted to the city to convert those units into a condominium. If the tenant had received that notice prior to moving in, then the relocation would not apply. If the landlord is looking to replace the resident manager with another resident manager, so there's a resident manager living there and that unit is being changed to a different resident manager, there's no relocation that would apply then. The next reason is the order to vacate was due to hazardous conditions caused by a natural disaster. So if the unit becomes uninhabitable as a result of an earthquake, for example, then the landlord would not be paying relocation for the tenant to move. The last step is the tenant, if the tenant receives relocation, an equal or greater amount from the government or by some other legal requirement, then the tenant would not be eligible to receive more than that amount. If that amount is less, then certainly the tenant would be eligible to receive the difference. So when is the relocation paid? It's within 15 days of the termination notice. There's 2 options that the landlord has. The first is within 15 days of the termination notice. The second option, and it's at the landlord's option, not at the tenant's option, the landlord may deposit in an escrow account or with the landlord's attorney for disbursement upon certification of vacation or sooner for actual relocation expenses. So as the landlord sees that the tenant has started to move, the tenant comes back and says, I found another apartment, I'm moving, they're asking me for security deposit. That would be a reason for the landlord to issue a part of the relocation fee. The tenant says, I need to turn on the utilities at the new location. That would be another mechanism by which the landlord would start distributing the relocation fee. Now, if at the end of it, after the tenant has shown all of the receipts for moving, if there's a difference, the tenant is entitled to the balance, even though they don't have a receipt for it. That would certainly go to the inconvenience of them having to move. So if the landlord is asking to vacate, again, there's either a 3-day notice or a 30-day or a 60-day notice, depending on the basis for the eviction. That is covered under state law, and we'll discuss that. On the notice itself, the landlord has to state the reasons for termination and include enough facts that the tenant would be able to understand the reason for the eviction. So that's something that needs to appear on the notice itself. And under those 4 conditions where the relocation is required, then the landlord also has to notify in that notice to the tenant that the tenant is entitled to relocation. So those 2 things must be on the notice to quit. In the city of Glendale, the additional way in which the city attorney's office may be helpful to you as a tenant is this section of the code that prohibits retaliation. And that basically says that no landlord may, with the retaliatory intent, bring an action to quit, cause the tenant to quit involuntarily, serve notice to quit, decrease services, increase rent, or threaten to do any of those actions with the intent of retaliating against the tenant. And the ordinance provides that retaliation is presumed. And what that means is if the tenant exercises a right within 180 days of the landlord taking any of those actions, then retaliation is presumed, but that presumption is rebuttable. So let me just take a moment to explain that again. If the tenant, if the landlord takes any of those actions to evict or threaten to evict, to cause the tenant to move involuntarily, reduce the services that the tenant used to have before. For example, they used to have a heated pool and they no longer have. The pool's no longer heated. Those are services that the tenant used to have, but after exercising a right like calling the city's housing department to complain about habitability, if the landlord's actions are within 180 days of the tenant exercising that right, then there is a presumption that that action is retaliatory. Now, the landlord has the opportunity to rebut that presumption. What does presumption mean? This generally comes up in court. That means that the court must find the existence of the facts presumed unless and until its non-existence is proven by a preponderance of the evidence. So then you have to go to court, and while you're in court, the court presumes that the action was retaliatory, and the landlord has to take steps to show that it wasn't. So that's what the rebuttable presumption of retaliation means. And what happens is if a tenant feels that a landlord is retaliating against them, then that is something that our office investigates. And if we find enough evidence, then that's something that we would prosecute through our office. The penalties for violation, first violation is $250. Second violation is $500. Third violation is prosecuted as a misdemeanor, which carries with it a jail sentence. So that's the extent of the prepared presentation I have, and I've gone through it pretty quickly in talking about what the law is in the city of Glendale. If you've got questions, I encourage you to approach me outside, and I can help answer those.
Is there anybody here who is not concerned about rental in Glendale? Yes, okay. Are you concerned about a rental in Los Angeles? Pasadena? And Silver Lake. Okay, Silver Lake, Los Angeles. Okay. So it just, most of my comments are addressed the city of Glendale, but there are some differences in rights depending on where you live. So I'm here to talk with you primarily about tenants and foreclosures. And as part of that, I will also be addressing questions about security deposits and about the eviction process. The first question that I wanted to address with regard to tenants and foreclosures is whether, when a property is in foreclosure, whether the tenant must still pay rent, whether the renter must still pay rent. And the answer is yes, the renter must still pay rent, either to the original landlord or when the property changes owner, then rent is owed to the new owner. You might not know how to pay the new owner, and if you're not if you don't know how to locate the new owner, still put that money aside, because if rent is demanded of you, you will have to pay it. The next question is, when a landlord's property is foreclosed on, does the tenant have to move? And the answer is maybe. The new owner must give a renter written notice 60 days before being required to move, and that is a recent change in the law. Only renters get 60-day notice, so if they're homeowners, they are not entitled to the 60-day notice. That's only for renters. And if you have a lease, you may get more time. What is the difference between a lease and a regular rental? A lease would be sort of a contract to rent the property for a certain period of time, for 6 months or a year, as opposed to a month-to-month tenancy. So if you have a contract to rent for a longer period of time than month-to-month, you may have additional rights to stay in the property. And it depends on timing. So in that situation, you want to talk to a lawyer. Questions about, if you have Section 8, what happens when the property is foreclosed on? After foreclosure, the Section 8 contract continues. The new owner should give tenants a reason before requiring a tenant to move. The law is not entirely clear on that. So you may also, if you're in that situation, consider requesting a new voucher to move, talk to your housing authority, and get legal advice. Next question is, what happens if you are in a jurisdiction that has just cause? In Glendale, as Lucy just explained to you, we have just cause. So this applies to all of the jurisdictions that are here except for Pasadena. When you have just cause eviction, the new owner must have a legal reason to evict. Even if the property was foreclosed on, the new owner must have a reason for eviction. So the new owner cannot just say, I'm a new owner, I want you to move out. They have to have a reason. And they may also owe relocation assistance. For those of you who are in a rent control jurisdiction, which would be Silver Lake or the City of Los Angeles, again, rent control does apply, similar to just cause. Rent control does not apply in the City of Glendale, and it does not apply in Pasadena. Next, if you're talking to people who are living in a place that has been foreclosed on, you may have heard them talk about a cash for keys agreement. And so I just wanted to address, what is cash for keys? When a property is foreclosed on, the new owner is usually the bank. A bank or a real estate agent for the bank may offer you money to move. If they do, it's your choice. And remember that in Glendale and in Los Angeles, you may be entitled to relocation assistance as well. However, just know that if the bank offers you money to move, it's your choice. And if there is no rent control or no just cause ordinance, the bank does not have to offer you money to move. So you can choose to take it or not, but there's no legal requirement to pay you to move unless there's just cause or you're under rent control. So next, there are questions about security deposits. In general, the maximum security deposit that a landlord can require a tenant to pay is either 2 months' rent if the property is unfurnished, or 3 months' rent if the property is furnished. After a renter moves, that money must be repaid within 21 days. If it's not repaid, the owner must explain why in writing. And the owner may not charge for ordinary wear and tear. With regard to when a property is foreclosed on, there can be questions about who owes the security deposit. In general, both the old and the new owner are responsible for repaying the security deposit. There's an exception if the old owner gives written notice to the renter that the deposit has been transferred to the new owner, then only the new owner is responsible for repaying the security deposit. And in general, you have a right to sue either the old or the new owner in small claims court if the security deposit is not repaid. And again, the exception is if the old owner gave you written notice, hey, I transferred the deposit to the new owner. We take the position that this applies even in a situation where the property has been foreclosed on. There are some reasons why the law may be not entirely clear, but we take the position that that is the case, and that a California statute says that any new successor in interest owes you the security deposit. So the new owner would owe you the security deposit. As you know, there are many opportunities for cheats when it comes to foreclosure. So we just wanted to sort of say to watch out for a few things. People may try to rent a vacant property to you who don't own the property. And you've probably seen some news stories about that. So when there's vacant properties, people may just pose as the property owner and try to collect your money. People may also, when you're still living there, approach you knowing that the property's been foreclosed on and say to you, I'm the new owner, pay me, but they're not really the new owner. So if you are not certain that the new person is the new owner, you can ask them for proof, and you can also call the Los Angeles County Tax Assessor. And the Los Angeles County Tax Assessor can tell you who their record is of who the owner is. And you have up here the number to call for the tax assessor. It's 888-807-2111. And I'll repeat it again slowly. Again, the number for the Los Angeles County Tax Assessor to find out the location of the office where you can find out who the owner is 888-807-2111. So to be clear, when you call that number, they're not going to tell you on the line who the owner is, but they will tell you which office you can go to and how to find out. So next I want to talk about evictions. When a landlord wants a tenant to move, they must go through a legal eviction process. And this applies in foreclosure situations as well. The first step in a legal eviction process is to give notice, written notice to move. The most common reasons that might be stated in the notice, they could be a 3-day notice to pay rent or quit, which means to pay rent or move out. A 3-day notice to perform or quit, which means to complete some promise that you've made under your rental agreement or move out. And that would be, for example, in a situation where there's a pet that you hadn't agreed in advance could be there, or where there's late fees that are owed. The next would be a 30-day notice for tenants who've lived in a property less than a year. Next would be a 60-day notice for tenants who are in a property that's been foreclosed on, all tenants, no matter how long they've lived there, as well as for tenants who've lived in a property for more than 1 year. Next would be a 90-day notice for most folks who receive Section 8. And then a reminder that if you're in Glendale, there must be a reason. Also, if you're in Los Angeles in a rent-stabilized apartment, there must be a reason stated for eviction. After the notice expires, if you don't, you have a choice when you get the notice to comply. And if you don't comply within the time period, the next step is for the landlord to file legal eviction proceedings. You would know that the landlord did that because you would receive a summons and complaint. That's the start of the court process. When you're just at the notice stage, there is no court process. When a summons and complaint is served on a tenant, the tenant has a window of 5 days to respond. After that 5 days, it's a race to the courthouse, and if the landlord gets there first, the landlord wins by default. If the tenant gets there before the landlord, then the tenant still has an opportunity to file a response. The third step after you receive the summons complaint is actually filing an answer. And in filing an answer, that's the tenant's opportunity to state why the landlord should not evict. And some common reasons that a tenant might assert would be that the rent that the landlord is claiming is not actually owed, that the rule that the landlord claims was broken wasn't actually broken, that the landlord's stated reason for eviction isn't true or isn't valid, that the landlord is retaliating against a tenant for example, complaining about living conditions, or maybe some other reason as well. And our office has self-help centers in 8 courthouses throughout the county where we assist tenants with completing answers if that is needed. We assist both tenants and homeowners and property owners with eviction concerns. So we actually assist tenants, homeowners, and property owners with regard to unlawful detainers at our court-based self-help centers. If you want the locations of our self-help centers, we have that in the table just outside the door. The next step after you file an answer is a court trial. If a tenant does not file an answer, there will not be a court trial. So only if an answer is filed will there be a court trial. On the date of the trial, there are a couple of different results that may happen. The tenant and the owner might negotiate a settlement. So they might agree, okay, I will move out in a certain period of time, you will waive the rent. And in exchange, there won't be any judgment. That would be a sample agreement. If the tenant and the owner do not come to agreement about how to resolve it, then the judge will decide. The judge will hear the tenant's reasons will hear the landlord's reasons for why they want to evict. They will hear the tenant's reasons for opposing the eviction and will decide whether, based on the law, the tenant must move. And be aware that in many cases, the judge can't take into account hardship. Sometimes the judge can, but many times the judge can't take into account hardship. If the tenant wins, then they stay and you continue paying rent. So it's very important, if your intention is to stay, to continue to set aside the rent because it's going to have to be paid eventually. If the tenant loses, then the next step is that the tenant will receive a notice to vacate from the sheriff. That notice to vacate gives a minimum of 5 days before the tenant is forced to move out. Be aware that what I've just described to you is the legal eviction process. A landlord or a bank may not simply change the locks, cut off utilities, remove doors, remove belongings, or take other steps to force a tenant to move. A landlord must get a court order, or a bank must get a court order in order to force a tenant to move. Now, at the same time, also be aware that if you are forced to move through a court process, if a tenant is forced to move through a court process, that it could affect the tenant's credit and the tenant's ability to rent or purchase later on. So kind of going back to the first step of our process where we talked about notices, if you comply with the notice, you're never in the court process. If you don't comply with the notice, then you're in the court process, and the risk is eventually an eviction judgment. If there is an eviction judgment, the eviction will show up on the tenant's credit report. Yes, for 10 years unless the judgment is renewed. And the exceptions to that would be if the tenant moves out before the 3-day, 30-day, 60-day, or 90-day notice expires, if the landlord dismisses the case, if the court orders that the case is confidential, or if the tenant wins in court. All of the information that I've covered about tenants and foreclosures is covered in a flyer that we have. We have it in multiple languages. And we also have additional information about other services that we provide to low-income residents of Los Angeles County.
Hi, everybody. My name is Karina Arabalaz. I'm with the Housing Rights Center. I'm going to talk to you about the fair housing laws. So first, let me introduce to you who the Housing Rights Center is. We're a private nonprofit organization. We've been around since 1968, since Congress approved the Fair Housing Act, and our services are free. We provide landlord-tenant counseling. We have counselors who can assist clients. That includes tenants, home seekers, landlords who want information on what the law states and how they should go about taking steps to address a problem or something like that. Our counselors can assist clients in 7 different languages, including English, Spanish, Korean, Mandarin, Cantonese, Armenian, and Russian. Our counselors also screen for housing discrimination complaints. Maybe a caller is not sure that they have been discriminated against according to the law, just that they're calling for information. But maybe our counselor can identify the situation as discrimination. So our counselor takes that complaint and passes it on to our next program, which is our investigations department. And their job is to do exactly that, what the title says, investigate that complaint. We also have a legal department that they do advocacy work, and they also assist the organization with their legal matters, and our outreach and education department. So I'm going to talk to you as briefly as I can about the fair housing laws, who is protected, and provide you with examples. There are 2 important fair housing laws that exist, and that is the Fair Housing Act and the California Fair Employment and Housing Act. One is a federal law, and of course the second one that I mentioned is a fair housing law in the state of California. Okay, where do the fair housing laws apply? They apply to all housing transactions, so that includes renting, buying, lending. Someone who's looking for a place to live is also protected under the law, so you don't actually have to live somewhere to be protected by the fair housing laws. And what type of dwellings does it cover? Well, it's any place where you can call a home, basically. So multifamily apartment buildings, condominiums, single-family homes, duplexes, residential motels, transitional shelters, mobile home parks, even campgrounds. So the application of the law is very broad in terms of the transaction that's involved and also the type of dwelling that's involved. Next slide. So the Fair Housing Act, which was passed in 1968, basically provides freedom of housing for everybody. And freedom of housing means that we all have the right to live where we want to live as long as we can afford to live there. Okay? And it says that landlords cannot discriminate against people based on one of these characteristics or a combination of them. Actual characteristic that someone has or their perceived characteristic. The characteristics are race, color, which refers literally to someone's color of skin, religion, sex, which of course involves someone's gender, and in sex we also have the protection against sexual harassment. National origin refers to someone's nationality, the country they were born in. Familial status refers to families who have children under the age of 18 living in the household, and this includes children, biological children, adoptive children, foster children, children in legal custody, and pregnant women. So if a grandmother has legal custody of her grandchildren, but the landlord says, well, you know, when I rented to you, it was just for yourself or for your couple, and now you have children, I don't want you to live here because you have children. That would be denying a family with children housing. The last characteristic protected under the law is disability. So people with disability, physical and or mental disability, are protected from discrimination. Now overall, what the Fair Housing Act is trying to set forth is that everybody should be treated equally. Everybody should be provided the same opportunity to obtain housing. They should be provided the same services, regardless of what their characteristic or combination of characteristics is. For people with disabilities, there is one small exception. Someone with a disability has the right to request a modification or an accommodation of their property, and that request has to be necessary because the tenant has a disability and reasonable. Modification requests refer to structural changes to the property or to the unit, so this individual can have equal access and equal enjoyment of the property. Okay. For example, requesting the landlord to have an access ramp installed or installing grab bars in the shower. Okay. Sorry. An accommodation request in turn refers to changing the rules or the landlord's policy at the property. A very common one that we deal with, landlords in California are allowed to have a no pets policy. But can anybody think of a situation where a tenant with a disability might require of an animal? You can agree with me or someone can shout it out, yeah. For example, someone with a disability may require a service animal, such as a guide dog, or an emotional support animal, for someone who suffers of clinical depression. So the fair housing laws state that the tenant with a disability has the right to request an exception to the landlord's no pet rule, and the landlord has to allow it. Remember, the law says that the request has to be necessary because that individual has a disability, and it has to be reasonable. Okay. The sexual harassment portion, those two additional, it's just situations that are considered sexual harassment. Quid pro quo is asking for a favor in exchange of a service. So let's say a manager asking a tenant out on a date and offering to fix their window. That could create a quid pro sexual harassment situation. Or the housing provider can create a hostile living environment, such as touching someone, hugging them, making comments on their physical appearance or dress. Okay. So let's see the California Fair Employment and Housing Act. And there are a couple of characteristics and other additional laws in California that protect us from discrimination. So the first bullet point says 1968 FHA protected classes. The 7 characteristics I just presented to you are also protected in California. So California gives us the same protection as the federal government. But in California, the government has decided to provide us with additional protections based on marital status, ancestry, sexual orientation, and income source. So an individual cannot be discriminated against because they're single, married, widowed, divorced. Ancestry discrimination would occur if the landlord and a tenant, they are both from the same race, same national origin, so basically they're from the same country, but they have different ancestors. For example, a landlord and a tenant, they're both Native Americans born in the United States, but the landlord is Navajo and the tenant is Sioux. 2 different ancestral groups. And the reason that there's discrimination occurring is because of that. Sexual orientation. An individual is protected from discrimination if they're heterosexual, gay, lesbian, or bisexual. Income source. Now this is a strange one, right? The California Fair Employment and Housing Act says that regardless of where a person's income comes from, meaning the source of that income, they have the same opportunity to apply for housing as anybody else. We have found situations in which landlords automatically decide that a tenant does not qualify without giving them the opportunity to apply because they don't like where that person's income comes from. Let's say a prospective tenant who receives SSI, and the landlord, instead of allowing this person to apply for the vacant unit, the landlord automatically assumes or presumes that this individual won't be able to pay their rent without at least giving them the opportunity to apply. This is what this characteristic is meant to protect, at least the opportunity to apply. It's possible that everybody's given the same opportunity to apply, but they don't qualify. Okay? But that's after everybody has applied. In addition, in California, there are other laws that protect us from housing discrimination. The Unroofed Civil Rights Act, which regulates all business establishments from discriminating against individuals, includes all the characteristics that we just talked about, but in addition adds age as a characteristic that's protected from discrimination. And because housing or rental housing is a business, the Unroofed Civil Rights Act also applies. So landlords cannot deny housing or discriminate against someone because of their age, and this applies to everybody who's 18 and over. Okay. Can anybody think of an exception in which, in order to qualify for housing, you have to be of a certain age? For example, senior housing. Okay. That's the only exception to this law. And the Ralph Act, the last bullet point right there, it protects us from violence or intimidation. And this is a civil remedy to a hate crime. And the reason it exists in housing is because the perpetrator of a hate crime could be the housing provider, could be the landlord or the manager, or it could be another tenant at the property. Okay? And this protection exists, or this civil protection exists. Let's go over what is housing discrimination. So refusal to rent, sell, or lease a dwelling or insure a dwelling. Remember, I said earlier, any transaction in housing would fall under the fair housing laws. Refusal to provide a reasonable accommodation or modification request to someone who has a disability. Differential treatment, and it has 2 more bullet points. There you go. Providing tenants different terms and conditions based on one of their characteristics. Let's say a landlord who charges a higher security deposit to families with children than to families without children. That would be different terms based on familial status. Different treatment would be treating tenants differently or providing them different services because of one of their characteristics. Let's say a landlord who only does repair for women and does not do repair for men. That would be discrimination based on gender. When a landlord makes a statement of preference, so verbally states the type of tenant that they want living at the property based on the characteristics protected under the law, they are violating the fair housing laws. So a tenant saying, I have a good example. I have a coworker whose landlord told her she preferred young single women living at the property. That's a clear violation of the fair housing laws. Okay? Also, landlords, when they advertise their vacancy, they should be careful of what they say in that ad or classified ad or wherever they choose to publicize their vacancy. For example, this is a made-up kind of ad that we did, but it says beautiful, spacious, 1-bedroom for rent, brand new hardwood floors, Venetian-style balcony with view of park, quiet professional building, close to supermarket and church. There are a couple of things wrong with this ad. One, the word quiet implies that landlords may not want families with children living at the property, even though it doesn't say that they don't want families with children. Professional building may imply that landlords don't want someone who receives certain type of income. Let's say someone who's on SSI or welfare or receives disability. Or even families with children, in which one of the parents may be a stay-at-home parent. Close to supermarket, well, there's nothing wrong with that one. But the next one there is. Referring to a religious institution close to the property may imply that the property owner or landlord wants people who attend that religious institution to live at the property. Okay. Whenever a landlord makes threats or intimidates, harasses, or coerces a tenant based on one of their characteristics, that's also considered a violation of the fair housing laws. Steering. Steering refers to when the landlord suggests that a tenant should live in a certain neighborhood or in a certain part of the property. Remember, the essence of the fair housing laws is that everybody has the freedom to choose where they want to live. Okay? So let's say a landlord suggesting that Latinos should live on the east end of the building versus African Americans should live on the west side of the building. Okay? That's housing discrimination based on race. This is an example of a possible violation of the fair housing laws in which there's an apartment for rent sign outside a property and it's declaring a preference. It's stating the type of person that they want living at the property, adults. So that might mean that they don't want families with children living at the property. Lying about the availability of a dwelling. If a property has vacancies and they're advertising it, such as in this way, with a sign outside, or it could be a classified ad in a newspaper or a magazine, and an individual calls to inquire about the vacancy, but they are told that it is no longer available, when clearly there is something advertising that there is, that could be a violation of the fair housing laws, because this is a tactic that's used sometimes by landlords to select the type of tenant they want living at the property based on the way that person looks, based on the way that person sounds over the phone. For example, if I had my husband call who has an accent when he speaks English and he is told that there is no vacancy, and I call a couple of hours later and they tell me that there's nothing, that there is something available, and to make an appointment to go see it, then they might not want people who have accents or who come from other countries or who have another race, for example. If anybody has any questions, more detail about some of these characteristics which are protected under the law, of course, you always have the resource to contact our office. Our services are free. We have this toll-free number, which is 800-477-5977, and counselors are available to assist clients in 7 languages. Or you can visit our website for additional resources. The website is www.hrc-la.org.
My name is John Brownell. I'm a senior supervisor with Neighborhood Services. I don't have any slides here, but I do have a couple brochures that are out on our table that will give you all of the information that I'm going to talk about today. Again, I work for Neighborhood Services. My responsibilities is supervising our code compliance unit as well as our rental housing inspection program. Our rental housing inspection program is a program where it's a proactive program where we inspect residential housing units, 2 units or more on a residential property for basic habitability standards. And what we do with that program is we check just for some basic standards, making sure that the units are safe, clean, and habitable. Our code compliance section is a reactive program, and that's where we receive complaints from members of the community where they feel things are not being maintained to the city standards, specifically housing units. The responsibilities of landlords within the city, we do have quite a few requirements that they must follow. We do, like I said again, is we do have brochures. The responsibilities for the owners are in this green brochure. It talks about what owners must provide with regards to rental units, how they must maintain them. Specific requirements that we require from owners for basic habitability standards is before a renter rents a particular unit, they should check for quite a bit of the following items here. When you inspect the unit, you should make sure that all the toilets function, all the sinks function, they don't have any leaks or anything like that. You want to make sure that the paint in the units are in good condition. You want to also make sure that the windows and doors are in good condition. The locks lock, they open and close freely, and you have no broken windows or hardware on the doors. You also want to make sure that the units have all their smoke detectors that are in place and they're operating. When you do the initial inspection on the units, before you pay any money or sign any contracts, you want to make sure that you check with those. Usually most smoke detectors have little buttons you can push to make sure they operate. You want to make sure that the electrical outlets work. You want to make sure that the walls are clean, carpets are clean. Check the ceilings and see if there's any stains on the ceilings. Usually that means that there's potential roof leaks and things of that type. Owners are responsible for making sure that all those requirements are met before you rent. You do not want to go into a unit where you have or you observe some of those items within the unit. We also hold the owners responsible for upkeep on the exterior of the building as well. So that's the painting, landscaping, making sure that they have proper areas for parking, and if they do provide parking there, that they're being maintained in such a manner that they're available for their tenants and they're in good condition. So once again, is before you go into these units, you should always check before you sign any agreements or put any deposits down, make sure these things are in good working order. Because once you have entered the unit and signed the contract and are now living there, there are some responsibilities that we will then hold the tenants responsible for. And these are pretty much basic upkeep and cleanliness of the unit. When you go into the unit, if you have issues with dirty carpets, we will ultimately hold the tenant responsible for that, and such that we take the assumption that before you went into the unit that the carpet is clean. Things like torn carpet and torn linoleum, we hold the owners responsible for that. But again, the tenants are responsible for basic upkeep and cleanliness. Mildew in the bathrooms are a tenant's responsibility. They need to make sure that those areas are ventilated. They need to make sure that, after you use the facilities, that you clean up after yourselves. You use proper cleaners in that to clean off the mildew along the tub and along the corners and like that. We also hold tenants responsible for how they manage their items in the home. And what I mean by that, we have individuals that happen to collect a lot of type of things, and they store them on the property. Those things need to be stored appropriately, either in garages or in appropriate storage devices. When those things become clutter and create issues where people who live inside units can no longer get in and out of the units, so they block windows, block required doorways. Those things become a concern to us just because if you happen to have a fire or some other issue, we want to make sure tenants will be able to access or get in and out of that unit pretty freely, as well as emergency personnel be able to get in and out of the unit freely. Again, I'm going to just keep this really short. What I do is outside at our booth in Neighborhood Services, we do have 2 different brochures. These explain all the requirements that we have within the city. One is for tenants, one is for the owner's responsibility. If you do have questions or if you have concerns with the unit that you happen to live in, feel free to give us a call. I have 7 inspectors that are available to come out, take a look at your unit. We work hand in hand with both the tenants and the owners of the property. Our bottom line is to make sure that units are safe for people within this community to live in. We do not advocate for one party or the other. We are a neutral party. But again, as we are here to support what our standards are for housing units.
Good afternoon. My name is Stephen Kozis. I'm an analyst. I work in Neighborhood Services. Thank you, John. And the Glendale City Council enacted on October 7 a new ordinance in the city of Glendale that restricts smoking in a lot of areas of the city. And the way I wanted to present it to you today is how the ordinance affects apartment buildings and the common areas of apartment buildings. There's a great deal of more areas that the smoking ordinance covers besides apartments. It also covers open areas in the public, which includes parks, libraries, all the city property, shopping malls, many other places within the city, including outdoor dining areas. But what I want to tell you here today is how this affects apartment buildings and the common areas of apartment buildings, okay? The most significant thing here is that smoking is not allowed on the common areas of apartment buildings. This includes this entire list that's here. Those are called common areas, such as mail room, laundry room, pool deck, gymnasium, elevator, courtyards, walkways, hallways, stairways. There are so many areas that everybody can get to in an apartment building, and now those will be smoke-free starting November 6th. Okay. Smoking is not allowed also within 20 feet of these areas. Okay. So if there's an open window, if there's doors, or entrances or exits, or air intake vents, which include air conditioners, there's no smoking within 20 feet of those places. So wherever the property lines are for apartment buildings, there's also no smoking within those 20 feet. Okay. You might ask yourself, so where is smoking allowed in apartments? There's 3 places, really. In Glendale, smoking will be allowed inside of units, not outside. It will also be allowed on the private balconies and private patios that are attached to units. So these are the places where generally people can't get to unless they go through someone's private unit. Okay? And the 3rd place in this area is in a smoking permitted area. A landlord may, if he or she likes, they may make a smoking permitted area subject to regulations. And the requirements here is that smoking permitted area has to be outdoors. It has to be clearly marked. This is something like a painted line on the ground, okay, or something else that clearly marks the perimeter of the smoking permitted area. It also has to have a sign that says smoking is permitted. It may only be up to 40 square feet. It can't be any larger, but it may be smaller. It also needs to be 20 feet away from entrances, exits, open windows, and air intake vents. So they might put this in somewhere in the parking lot, if you will. Even though it may not be 20 feet away from a parking lot, the ordinance allows for it to be in areas where it's 20 feet away from entrances, exits, open windows, and air intake vents. Lastly, it also needs to have at least one smoker's waste receptacle. This can be an ashtray. This can be something that can receive cigarette butts. You may have seen some on the streets that have a large can at the bottom with a tube that comes up to the top where people can put in their cigarette butts. The smoking permitted area must have at least one of those in apartment buildings. And the next piece on disclosure. This is an important piece for prospective tenants. So the next time you shop for an apartment in Glendale, a landlord will need to disclose to you where smoking is permitted and where it is not. And they need to show you this on a piece of paper, like a floor plan, that shows the position of the units relative to one another. So landlords must designate their units as smoking or non-smoking, or a combination of those. They also must tell you here if smoking is permitted in the unit that you want to rent, and also they must tell you if it was designated as a smoking permitted unit previous to you. And also, like I told you here, the landlord must provide a floor plan that shows the position of the smoking and non-smoking units relative to one another in the complex and where the common areas where smoking is allowed and not allowed. What's important here to know is that the landlord doesn't need to know if you smoke or not. They don't need to know if the person smokes. What they're saying is, like in a hotel room, this unit you may smoke in, and this unit you may not. They don't need to know whether somebody actually does. Okay? If they're going, some landlords have already taken the steps to make their buildings smoke-free. That's perfectly within their legal rights to do, just like they make policies about pets or the hours you might use a swimming pool or similar policies like that. So this would be another policy decision for that landlord. They may decide to make all of the units smoke-free. They may say that all of these are smoking allowed. Fair enough, that's okay, as long as they tell everyone who's shopping for the apartment where those units are. I don't have anything further as far as details. It's pretty simple as it applies to apartment buildings. People have a lot of questions and concerns about the units that they live in. So if you have concerns about the unit that you live in or the situation that you're in or the building or how you might discuss this with your landlord and how they might change the building where you live, please see me.